Good morning, everyone. Hope everybody's well.
Good morning.
We've got great attendance today, and I thank everyone for giving time up today. Just going to leave it another minute or so. My colleague in the background is just admitting people into the room as they join, but we've already got 22, 23 just joined at once. So making sure everybody's got through the single door access, okay, and had their passports scanned and all that. Right to work checks. I'm sure that's on everybody's agenda as well, with all these things that are going on in the HR world. I think we're going to make a start, Emma, if that's good for you and everybody here. Thank you all for attending today. This is our third webinar in the series of building up and getting ready for these biggest changes in employment law that have come about for somewhat of 30 years. They all started in 2023, late 2023, where the parties, the main political parties, were starting to get their manifesto pledges together for their campaigns that came to a general election on the 4th of July 2024. Labour government got in there. I think everybody's aware of that and how things have been for the last 18 months or so. But Labour government bought a manifesto pledge that were due to rewrite and update and modernise employee working rights and protections. Some of the biggest changes that we've seen. We had the Equality Act in 2010, but really a lot of this falls under what was known as the Employment Rights Act. The very first iteration of the Employment Rights Act was in 1996. So when I say it's the first major change and update in employment laws for some 30 years, it's really testimony and shows that the Labour government were intent on making a lot of changes. When they set out in that manifesto pledge, there was something like 400 intended changes to employment rights and provisions to protect workers and all workers more so. Some of the big ones that were intended, particularly cast your minds back, was to give employees a day one right against unfair dismissal. Now, as we see through this presentation, that didn't come about, and those 300 or so employment rights that were proposed in the manifesto in July 2024 got into the employment bill that we've now got what's come into the Employment Rights Act of 2025. It only just snuck into 2025. It came about on the 22nd of December. It was the last act of Parliament to get ratified after a number of threads through both Houses of Lords and Houses of Commons to get where we're at. And where the Manifesto Pledge and the Employment Rights Bill started in 2024, in the autumn of 2024, has really come down from 300 or so proposed changes to about 30, but 30 of them are not going to apply to 99% of businesses because of trade union involvement and consultation rights and obligations and duties and those kind of things. And I'm not going to labour on those today because I know it won't affect all, if any of you, in terms of those changes. But there are 6 or 7 really fundamental changes that I'm going to share with you today. Share what the changes are, what our current practice is, and give some tips and some advice and some strategies to start thinking about where we go with these changes that are coming about. They are step change. They are coming in April this year, in October this year, later this year, and in January 2027. So we'll go through those chronologically to demonstrate what these changes to Employment Rights Act 2025 are going to mean for you as a business, as a manager, as an employer going forward, and some tactics and strategies for dealing with that. As I said, we first started publicising this in August, September last year, and it's really interesting to see the numbers. We had 6 or 8 attendees in July, August 2025. I did a similar this seminar in January about a month ago, and I had about 25 attendees, and currently we've got 31. So thanks again for everybody coming along this morning. As I mentioned, the Employment Rights Act is the most comprehensive act. It's the most common. It's the most relied upon by HR practitioners and employment lawyers, and how we interpret that and guide and support employers to make sure that they are compliant with it. And it's the biggest change since 1996, so some 30 years ago. What we're going to cover today are the key changes confirmed under the Employment Rights Act 2025. What the changes mean in practice for UK employers. And when I mean employers, I mean probably 98% of employers. The 2% who are employing hundreds and hundreds and thousands of people, probably public bodies as well, are not in that 98% of the SME world, the SME markets that most of you I know, if not all of you, are located within. Going to talk about what actions organisations should be considering now. And just a reminder that it is the 24th of February today. I know you all know that. Why is that significant? There's still a lot of things that are not absolutely crystallised, that are not watertight. And what we'll be doing as and any updates come about or any changes to what we've said, keep an eye out for our newsletters, keep an eye out for further webinars to talk about this. But this is based on what we are pretty sure, what the law is saying today, what the lawmakers and the government are saying is going to come about from April, October, and January 2027. The first major change in the framework is to do with statutory sick pay, in that it becomes available for employees from the very first day of their absence and their first day of employment. So what are the current rules here? You might all be aware of this. Well, first and foremost, an employee over a 12-week period must be demonstrating that they're earning at least £123 a week to qualify for statutory sick pay. There are 3 waiting days which are unpaid. So let's use this running analogy here, this scenario that on a Monday, Tuesday, and Wednesday, if somebody calls in sick and follows their sickness absence policy rules, they phone in sick on a Monday. Currently, they don't get paid on the Monday or the Tuesday or the Wednesday, and then they will be entitled to statutory sick pay from day 4. Some employers may have contractual sick pay entitlements that do change that. But I know from the majority that statutory sick pay is the way that people treat sickness absence. Currently, SSP is £23.75 a day and it's eligible for up to 28 weeks. There are some rules about having breaks, and if somebody does come back to work and then has a period back at work and then goes off again for the similar reasons, then that period is linked and it can carry on for the 28 weeks. But if they have a different condition, a different reason for that, say a mental health matter compared to a musculoskeletal matter, then they could be on a continuance of another period of sickness pay. So they are the rules today. From April, so little over 8 weeks' time, from the 6th of April, statutory sick pay will be available to all employees from the very first day of employment and from the very first day of sickness absence. Now, there was a lot of noise, a lot of rebuttal, and a lot of challenge from employers' forums about this, because they can see how easy, how much of a spike there will be in sickness absence and sick pay claims from the very first day of employment. So say I'm starting work with my new employer next Monday and I'm not feeling great, I can phone in on that Monday because I haven't got to prove that I've earned enough over those 12 weeks. I can phone in on Monday, and on that Monday after the 6th of April and say, I'm sorry, I'm not well enough. I'm following your sickness absence policy. I'm entitled to £23.75, or when that gets increased, it might go up to about £25 with the statutory increases in April. So I get it from the first day of absence. Still currently £23.75. It will increase in April, but that's not been announced yet. There are no requirements to demonstrate earnings, so this makes statutory sick pay available for every worker. The view the government had here that were part-time, low-paid national minimum wage workers who were part-time were perhaps not earning £123 a week to demonstrate that they could qualify for sick pay. Now, I get that, and that's fair, and people should be covered and protected. But what this is also going to do is open up a catechism of claims for statutory sick pay from day one. As we go through this presentation, I'm going to give you the tools and techniques and application of some consistent policies that will help manage these situations and mitigate any disruption. As I say, there's no waiting days. It's £23.75 from the very first day of sickness absence. Also in April, so from the 6th of April this year, paternity and parental leave is an entitlement from the first day of employment. The current rules, again, anyone applying for paternity or parental leave needs to demonstrate that they've got, over a 12-week period, a minimum earning of £125 a week. To claim for it, they've got to be employed for at least 26 weeks by the end of the qualifying period. Now, the qualifying period is 15 weeks prior to the expected week of confinement, the day that the baby is due to be born or the adoption is planned to take place. So it's 41 weeks. They need to be employed for 41 weeks before they are entitled to take and be paid for paternity and parental leave. They are the current rules. Statutory paternity pay is for 2 weeks and leave is for 2 weeks, and we can take it in blocks of 1 full week or 2 consecutive weeks with a break. Statutory paternity leave is up to 50 weeks and with 37 weeks paid, currently at £187 or 90% shared between the eligible partners. So the critical matter here is that for paternity and shared parental leave, there needs to be a qualifying period to be able to access it and a level of earnings achieved before they qualify. From April 2026, the new rules are separating here. So we've got to look at the leave and the pay separately. So crucially, anybody applying for paternity or parental leave does not need to demonstrate that £125 earning potential or earnings per week to qualify. So again, the same ethos, the same principle here that the government had was it was prohibiting people who were low earners and part-time from accessing this provision of law. But leave and pay were connected. The new rules in April disconnect the leave and the pay. So there are no requirements to be employed for 26 or the 41 weeks. Paternity and parental leave is available from the first day of employment. It's a statutory right. We can't refuse it. There are some processes to go through, but we can't refuse it. But what it doesn't bring through with it, and this is that disconnect, it doesn't come as a paid entitlement. So an employee starting employment and doesn't have those 41 weeks of continual service can't be in receipt or won't be entitled to receive paternity pay, statutory paternity or statutory parental leave. So they can take the time off, but they can't get the pay. Hope that makes sense. It's quite complex. It sounds like a big change, but I think there is a deterrent here that employees will need to take time off unpaid in a time of high cost of living and high inflation. I don't think that's going to be an opportunity many people are going to be able to take. And equally, if somebody is starting, say, I'm starting this hypothetical new job next Monday and I want to take paternity leave, I don't get paid for it, but I'm not going to be entitled to annual leave either because I won't have worked enough to accrue 10 days of annual leave. By the end of that month, I will have accrued at best 2.3 days of holiday for me to take. So it's going to be an absolute unpaid leave, no pay at all provision. So I think that will be quite a deterrent to a lot of people thinking about taking it from day one. We then hop forward to the 6th of October this year. Currently, anti-harassment, sexual harassment laws say that an employer must take reasonable steps to prevent sexual harassment at work. Those reasonable steps are having a good policy in place, or HR customers have that. Doing some training. We've got a toolbox talk on our portal, My THSP, and we should investigate and treat matters of sexual harassment really seriously. So currently the law says you must take reasonable steps. From October, it's really going to up the ante towards all reasonable steps. Now, all reasonable steps is objective in the eyes of the law, but what does that really mean for employers? Well, along with the current rules and the current steps to take reasonable action against sexual harassment happening, risk assessments might be a consideration. We will expand on the policy. We'll expand on those risk assessments. We do them for a lot of other tasks like health and safety. So it shouldn't be a alien process to consider, but we need to think about the work environment, the culture within the business, the industry, the opportunities for harassment to happen outside, inside and outside of our workplaces. We've got to demonstrate consultation with workers, and a good way to do that is through staff surveys. So it's autonomous. One-to-ones are a good way of dealing with that. Listen with people, ask them if they feel protected, if the company is doing enough to protect them from sexual harassment. Sexual harassment happens to everyone. We deal with cases of all denominations. It's not that specific to, say, a male acting in an inappropriate and unacceptable way against a female. It does happen in all ways. In terms of consultation, if you've got a safety committee, the things that you put on your agenda include risks, and sexual harassment can be a risk. The damage that it can cause both mentally and physically to people needs to be considered. So they're the kind of places we're going to be advising you put sexual harassment risk management on the agenda. THSP, we've put it onto our risk register, and we review that every month at our board meeting to see if there's any changes and update the way that we've been consulting and dealing with the matter in hand. Provide anonymous reporting systems, because not everybody is going to be comfortable to do that. It can be really embarrassing. It can be really personal if somebody's been abused or attacked in a sexual, with sexual nature as the connotation. So it's really important that we've got an anonymous way of reporting. And that might be that we've got, say, mental health first aiders or the go-to. It may be that there is an anonymous way of bringing that through a Microsoft form or something like that, that they can report and bring things to people's attention. These are all of the kind of all reasonable steps that the law is going to expect of us come October 2026. There'll be more to come. The law on that, the ink is still not dry, so there will be much more to come on that. And training is really important. Training at board level, so the board understand what the law says and what their policies and their duties are, is really important. Managers in terms of support and identification, and employees in terms of their role and responsibility and duties in preventing sexual harassment at work. And a good way of doing the latter is through toolbox talks. Some of it might be done through e-learning or face-to-face Teams meeting and training might be the way to make sure that message is understood and steps are being taken. The consequence after October is that a failure to demonstrate all reasonable steps have been taken could enable the employment tribunal to uplift an award to an injured party by 25%. You're thinking that there is no cap on harassment or discrimination claims. It comes down to loss of earnings and failure to follow procedure and injury to feelings and future earnings. You are starting to look certainly at high thousands of pounds, and a lot of cases go into the hundreds, if not millions of pounds. With 25% added to that as a penal factor for not applying all reasonable steps, the government think is a really strong deterrent. I think it's more than that, that we've got a duty to protect people whilst at work, whilst in their duty of work. One of the other things that is coming about in October is the duty to protect against third-party harassment. So if we're thinking that our employees are visiting sites or we've got visitors coming to our location and property, we've got to think about the rules that we've got in place. If we are sending people to our customer sites, it may be in our terms and conditions we consider that that business also has relevant protective measures in place to provide cover and certainty for our employees going to their place of work. They're the kind of things we are starting to work on, ready for October, and more information will follow in packs and proposed policy changes. So a lot in October. We've then got a little break until January, only a couple of months, but we've got a break until January. And this has been contended as the most significant change in employment law in some 30 years. As I said in the outset, the government wanted to remove the current 2-year rule around unfair dismissal rights. They wanted to remove that and bring that as a day one claim. That had a number of challenges at the House of Lords, in employers' consultation, and in the House of Parliaments. And it came back that a proportionate change, reducing this, would come about. So if you think about what the current laws are, what we've got today and for the next few months, generally, there is no requirement to demonstrate a fair process for employees with 2 years or less of continual service. Continual service accrues from their first day of employment. There is still protection against automatically unfair reasons that we need to be very mindful of. And we're always asking those questions. Are we mindful of any disabilities? Any claims of harassment? Has anyone made a whistleblowing claim that we need to think, well, could they perceive this, or is it connected to the reason we're dismissing them? If it were, then our advice would be to be very careful and cautious about that, because it could be perceived as automatically unfair. But generally, if someone's attendance isn't particularly good, or they're not settling into the job particularly well, or the business needs to restructure and remove that person because the work simply doesn't exist, then less than 2 years service, we should be in a pretty safe position to terminate the employment and not be fearful of any claim that might come along with it. This is all going to change next year. it gets this statutory protection for 2 years of service reduces to just 6 months. The qualifying period reduces to 6 months of continuous employment from the first day of employment with you. It introduces a statutory probation period for the very first time. Now, it's not called that, but I think the mindset and the clarity and the understanding would really help if we started to look at those first 6 months as a probationary period. And the techniques, the strategies I'm going to propose in a little while, all really emphasize where we do that. Now, everybody probably knows what a probationary period is, but currently it has no legal standing in employment law, except where it might increase notice pay or increase pay, or it might provide a provision like a car or some more holidays on the successful completion of that period. That's contract law. It's not employment law, and the provisions at the minute are still that umbrella of generally 2 years of continuous service to afford and get that protection against unfair dismissal. The government did propose and were really keen on having a light touch procedure. So having a performance review or a disciplinary within that 6-month period was also considered as a fair way forward. But the House of Lords and the employers forums kicked that into touch. So there is no light touch requirement. I mention that because there was a lot of talk about it last year, about how we might get to that. But essentially for 6 months service, other than for those automatically unfair reasons that I mentioned on the previous slide, we should be in a position that we can still end employment, terminate employment with notice, usually within that 6-month period. So here's the first matter of food for thought as we get into those strategies and how we might cope with matters going forward. We've got to think that employees engaged prior to 2nd of July 2026, so this year, by the 2nd of January, will have achieved 6 months of continual service. So ordinarily today, you'd be thinking, well, they're way short of 2 years service. But with this law change in January, anybody employed prior to the 2nd of July 2026 will have achieved that 6 months of continual service. There's food for thought as we move into the next few months and we get into the autumn and we're thinking about our resources for the next calendar year. Service accrued from the 2nd of July also counts. So it's not that the law comes in and only applies to people employed after the 2nd of January 2027. It applies to people already in employment. So if somebody has been employed from the 3rd of July 2026, they only need to work till the 3rd of January 2027 to have this 6-month protection afforded to them. I think that's really important to bear in mind, that a lot of the other laws are going to impact on the day that they're intended. This change in law has a pre-action to it that it will start to accrue rights and protection for people employed from July onwards. The government is also considering, and this is a matter that we expect or will be flushed out and clarified before January, but there is talk of removing the cap on unfair dismissal claims. Currently, it is capped at £118,000 or a year's worth of pay, whichever is the lower. So you can see that £118,000 really only impacts business owners, shareholders, C-suite executives. The new rules from January 27 is to propose that it is uncapped. Again, that won't affect the majority of people because the rule will still be that it is a maximum of a year's service, but uncapped. So put that into context. Somebody earning £250,000 won't be limited by the 118,223. Does that make sense, I hope? So it won't affect that many people. Right, the further change next year is regarding flexible working requests and support and evidence, and this is from July next year, from January next year. The current rule is that day one rights exist have been in existence since April 25. What does that mean? That an employee who joins on their first day of employment or even prior to their employment can make a request to flex their working arrangements, their place of work, their contracted hours, or common ways of doing that. The law from April 2025 also afforded an employee 2 opportunities in a calendar year to make a flexible working request. So if the first one is rejected, then they may apply again within that year and repeat and go on. I'm not seeing that. That's not trending. It's not evident that people are using this repeatedly or misusing it, as some people might say. Employer still needs to have justification for refusing or part accepting and part rejecting a flexible working request in compliance with the Employment Rights Act. There are 8 reasons there, like inability to resource, effect on quality and production, impact on customer satisfaction and relationship, inability to produce and in line with what the business needs. There is a statutory process and there is consultation and right to be accompanied and an appeal. People who make a flexible working request should not be treated less favourably because of it. And we revert to our policy and our processes for dealing with such applications. But there is a new aspect coming about this from January 27. It's all of the above, plus a requirement to consult with those the request may affect. So if somebody works in a team of 10, say, or job share and work with other people, tasks share and those kind of things, and they make a request to vary their hours of work, for example, reduce their hours of work and reduce their pay, and perhaps even work from home. Let's throw the 3 common reasons into there. An employer may say, well, Section 80G of the Employment Rights Act says that I can't resource it. It's going to have an effect on quality, production and cost and output and those kind of things. That all may seem very legitimate and still be applicable, but the employer has still then got to consult with the people in that team, in that department, that change in hours may affect. So we've got to put it to the team to say, we've had a flexible working request from Dave, and Dave wants to work 4 days a week, but he wants to also work one of those 4 days a week from home. What impact, what effect does that on the business? And we look at the reasons under Section 80G of the Employment Rights Act, and people may come up with a rationale, an acceptance, a workaround, a way of accepting it. Or they may also come up with some concerns, some objections, some challenges as to what effect that would have on the job that they are employed to do also. Lots more to think about when we're producing or preparing to deal with a flexible working request. The objective has got to meet business reasons. It doesn't fit company culture is not acceptable. We don't do flexible working is not an acceptable excuse and rationale to reject an application. Again, for January next year, guaranteed hours for 0 hours workers. The current rules are that there is no mutuality of obligation. There is no duty to offer a 0 hours worker any work, and there's no duty upon them to accept it. Workers, 0 hours workers, they have different rights to employees, and 0 hours workers are certainly defined as workers. But the new rules from January are that after 12 weeks, an employer has a duty to make available to that 0 hours worker an average amount of hours that they can work based on what has been their previous for the 12 weeks before that schedule is drawn up. So if the average says, for instance, that that person's worked 36 hours a week regularly, consistently, and on average over the previous 12 weeks, then the next 12 weeks, we should be offering them 12 weeks of employment. If they refuse to take it, then the rolling calculation takes on. So all of a sudden we've got 11 weeks at 36 and 1 week at 0. Then the average changes, and that averaging for future scheduled weeks as a minimum amount of hours we've got to offer the 0 hours worker may diminish, it may reduce. But this again is about giving certainty to 0 hours workers, about fairness and equality that the government say was way withstanding of employment rights. Will this have an effect, knowing the cases and the situations where 0 hours workers? I found typically that they are given and they do work very similar patterns to full-time or regular part-time workers anyway. So I think this is a practice to demonstrate and keep an eye on when things historically would have changed and hours would have been reduced. But still, the worker is not obliged to accept it. So there's only one-way exclusivity here, isn't it? That the employer has got to afford it, but the worker hasn't got to accept it. Further, with 0 hours and shift workers, the current rules are that there's no obligation to compensate. It particularly impacts employees with guaranteed or regular overtime. The new rules from 2027, if reasonable notice on shifts is given, then employers can be expected, or if it's not given, employers will have to pay and compensate those workers for a shift that didn't happen, was cancelled, or didn't conclude for the hours that were expected to be worked. Employers again have got to think about their record keeping and how often this happens. And one of the things you can be ready for here is to make sure that you've got terms and conditions that are back to back with your employment contracts. So if your customer is all of a sudden cancelling work at the 11th hour, your contracts will ensure that that person, that worker, is entitled to pay for it. So make sure that you are getting your rights, your opportunity to make that recovery from your customer. If a shift is cancelled, as I say, or moved or cut short at short notice, the employer must pay that cancellation fee or a fee or a short notice period. What the government have not identified yet is how short that notice has got to be. The intention, the proposal is that it's within a couple of days, but again, we've not got guarantee yet. More to follow on that. So getting ready for change. These are the recommendations and the advices and steps that we are seeing that employers should be doing now to get ready for change. Firstly, review your absence management policy. Our HR customers have this. Do they comply with it? Does everybody comply with the trigger days and treat that as it should be? Begs a question for me, but it must be applied consistently. Talk about records and how important they are, coupled with the changes for unfair dismissal laws in January 26. So what we are really advocating is that people consistently get those self-certification forms in. There's a box on the self-cert form that says reason for the absence. Don't allow it to be populated with sick. Get some reasons for it. Was it toothache? Was it backache? Was it influenza? Let's be specific about the reasons for that. Was it Was it because of other protected reasons for treatment, medical care, or anything like that? So it's really important we get those self-certification forms completed on the first day with good evidence on it. Conduct return to work interviews. Again, we've got a format for that. Was the policy procedure followed? Was good notice or expected notice given by the employee? Let's complete those records, because think about those changes in January. We've only got 6 months to identify if we've got a problem here and how we're going to treat that employee before we get into a more laborious, meticulous process like a medical capability or a prolonged disciplinary or performance management process. Have a trusted occupational health provider on hand. We work with a company called Adept. They provide really good reports quickly and give good management content for us to be able to make some decisions. When I go back to the absence management policy, within that, it does say that you will have the right to investigate or treat repeated sickness absence in line with your occupational health or your disciplinary procedure. And those trigger days are 5 within, as standard, 5 days within any rolling 12-month period. My question is, does everybody apply that consistently? My recommendation is that from April, we are applying that consistently to show fairness and equality to everybody in the company, no matter of their background and other medical conditions. In terms of paternity and parental leave, review and update policies and communicate those changes. Our HR customers, look out for an email on the 1st of March. These policies and changes in policy to sickness absence and paternity and parental leave will be coming out. The updates to sexual harassment and to disciplinary procedures will come about later in the year, as we're absolutely certain of what that law is going to look like. In terms of taking all reasonable steps, gearing up, this is a step change. This is a cultural change in a lot of businesses. And it's important now to start looking at policies, procedures, and how they are communicated. Start thinking about a risk assessment and communicate reviews regularly and implement control measures. So there's language there that you will all notice from health and safety law. It's the same kind of way of dealing with it. What is the risk? Are there control measures? What is the outcome of that? And we'll be able to devise a strategy, a way of treating and dealing with these obligations, these duties under sexual harassment laws come October this year. It's important to obtain views from staff, so think about including consultation in your one-to-one appraisals, your team meetings. Put it on your safety committee. It is a safety matter. Sexual harassment, any form of harassment and discrimination is a safety matter. Consider training for everybody, and the best way of doing that, the best way of communicating your policy, procedure, the rules, and how people can contribute to the protection of others in the pursuance of eradicating sexual harassment at work. Review the terms of trade that you've got with your clients, suppliers, etc., to state zero tolerance towards sexual harassment will be taken in your business. The origins of these changes were to protect people working in the hospitality trades, but notwithstanding that, there are still cases where I hear of visitors to site, or when at other locations, colleagues, employees are being subject to sexual harassment, and we need to make sure we are doing our utmost and protecting them as much as we can when we go to their sites. And a review of the rules, the site rules, might be a way to do that. It's a good way to get forward. Have processes for dealing with incidents, grievances, and complaints. We've got a grievance process. You will also have a harassment and bullying policy, and it's important that we follow that consistently in any case that is brought to our attention. and engage with the person who is on the receiving end, the injured party, the receiver of that conduct, to make sure that they're okay and they're supported and they're given every opportunity to have redress and a balance to what's happened. So what to think about doing for January 27 is ensure management are aware of all these changes. This reduction from 2 years, and 2 years is well known. It's been around for a long time. Employers come to me and say, this person's coming up to 2 years service. What are my options? They're not really fitting in. Their business doesn't need that role in the organization. Have I got a way of dealing with this? Yes, at the minute you have, but this is a cultural step change in law. This is going to have a profound effect on managers and managers' behavior. And as I've said throughout this, it's really important that we have a probationary review, that we've got mechanisms in place to review performance. If the dismissal or performance management comes after the 6 months of accrued service, then think about how we would treat a situation with an employee who got more than 2 years today. There would be a full statutory procedure, performance management, disciplinary, medical capability, redundancy. We'd have to follow those same steps. So over 6 months, we'll have those same rights as over 2 years has today. Update contracts and policies to clarify no obligation to apply a statutory process in dismissal where less than 6 months service is accrued. It currently says that for 2 years, but our updates will say within the first 6 months. So that contracts us out from having to go through a statutory process unless we absolutely need to. My key message is to review resources needed and objectives prior to the end of 2026. Consider notice periods in this time. If somebody has a 2-month contractual notice period, we've got to make sure our contracts have payment in lieu and early ending of employment. Otherwise, that 6 months all of a sudden becomes 4 months, doesn't it? And time will fly, time will pass quickly, and all of a sudden that 6 months will have been achieved. So a bit more awareness, I think, is really important. Short-term awareness and short-term management as well. If somebody isn't quite cutting the mustard and performing in those first few months, then think about doing a PIP, a performance improvement plan, or have a health review meeting with them if their attendance isn't where it should be, or their behavior isn't where the business would expect them to be at. When we consider all of this, we are in a claims world. There is no doubt about it. I'll be bold enough to say that 50% of dismissals, for whatever reason, disciplinary, OC health, redundancy, are getting challenged. There is a rise in AI, there's a rise in claims culture, and a rise in social media interference and noise and knowledge. As HR, as employers, it's really important that we go back to basics with some of our procedures now, even within those 6 months, to demonstrate the reasons, the rationale for terminating the employment within 6 months isn't for any untoward reason, any protected characteristic, anything that the employee may perceive, that we've got evidence that it's due to operational or business objectives. Flexible working requests, as they change next year, it's really important to conduct a transparent consultation with those that are affected and feedback to say that I've consulted with your team here and they've raised these following concerns that has aided me to conclude what the outcome is going to be. Or they've come to me and they've provided me a workaround and how this could work. And I'd like to accept, maybe on a trial period, your flexible working request. Again, update policies and procedures to make sure they're current and that they are communicated, so everybody is clear on that. This non-monetary cap on unfair dismissal awards, I don't think it's going to affect that many people, but make sure management are aware of it. given the claims world that we're in, I think it heightens the senses and awareness of that a little bit more. In terms of 0 hours workers, ensure the monitoring processes are in place. Similar that should be in place for holiday pay, national minimum wage, working time monitoring, the kind of things you would have in place for irregular working hours and perhaps lower working hours as well, to make sure you've got that ongoing compliance. And that you are offering 0 hours workers at least the average of guaranteed hours on that rolling 12-week basis. If it is flexing and changing, it's going to be a monumental admin task to keep an eye on that. But I think in most circumstances, there is consistency and regularity that will make that a little bit easier. In terms of compensation for cancelled or reduced shifts, check your terms and conditions with customers, your clients, to ensure you have scope to charge for short notice cancellations. So you're back to back and you're not going to be out of pocket if you get undone by a customer's decision out of your control. Right, we're getting towards the end. I'm open to stay as long as needed for Q&A, any questions. My colleague Emma's going to put in the chat and email out to everybody a checklist to see how people are doing in terms of readiness and preparedness for the changes that are coming about in April, in October, and then in January 2027. If you've got any immediate questions that are about resources and support, then please email sales@thsp.co.uk. I'm putting a lot out on LinkedIn. It'd be great if you followed me if you're not already. I know a lot of people here are. Do connect. I'm putting out updates. My team are putting out updates in terms of policy and procedures. There'll be one in March for the changes in April. So sick pay, paternity, parental leave policies will be issued out with those changes and updates. Then there'll be another, I'll probably do another seminar in early September to talk about what's happening in October, and a further update will happen in September then with the policies and procedures, and similar in December and January as we get ready for the changes in January. That then leaves me to say, any questions? Appreciate your time over those 53 minutes. Nearly on time. I hope that you found that useful and valuable. You've got something out of it. You'll get your updates. But if you've got any questions, complete that checklist, that readiness checklist, to see where you're at. And we're here to help you if you need support or you've got any questions. Any questions? Anyone?
I've got one, Andrew, if that's okay, please.
Please, Hannah, fire away.
Hi, how you doing? No, that was really informative. Thank you. I know this might sound a bit of a silly question, but I just want to make sure I'm where I need to be. With the SSP, obviously at the moment they require a doctor's note after the 4th day, don't they, to claim the SSP?
No, after the 7th day.
7th day, sorry. Is that going to be still the same case? They're still going to need to retrieve a doctor's note, aren't they? There's nothing like that is changing. It's just the scope of the days are changing. Is that correct?
Absolutely right.
That's what I just wanted to check.
So the first 7 days they can self-certify, and then after that they are required to get a Med3 certificate, either from their doctor, a physio, a hospital, a consultant, a surgeon, whoever.
Yeah.
The interesting thing about a doctor's note is the only legal reason it has its existence is for the facilitation of paying statutory sick pay. So it's mandatory that you have that Med3 certificate after the 7th day to be able to pay SSP. It has an impact on your NI and the DWP if they, or HMRC, if they did a payroll inspection, they want to see that you are doing that. So it's a really good reason to refuse or decline somebody continuing payment of SSP if they don't provide you with a Med 3 certificate.
Perfect, thank you. And just another question, Andrew, if that's okay. In regards to the shift work, obviously being in construction, we have a lot of overtime on the weekends. That can sometimes be cancelled at very short notice. Is that the same sort of thing in regards to the overtime as well? We would obviously need to pay them if it's under a certain amount of time, and just make sure that we can somehow clause that back from the customer. Is that correct?
100%,
Yeah.
yes. Particularly if it's kind of regular work as well. More often than not, that they are doing that weekend work and overtime, then certainly they will fall into this law change that's going to come about in January next year.
Okay, perfect. Thank you very much, Andrew.
Thanks, Hannah. Thanks for coming.
Thank you.
Gillian Roberts, would can you?
Hi.
I'm like, there you are.
Hi,
Gillian.
thank you. Thank you for taking my question. Just on the SSP again, as a business, we have company sick pay, which kicks in on day 4. Can we still continue to do that after April, or do we have to change that as part of the SSP changes as well?
So great question, Gillian. Do you put, when you pay company sick pay, do you pay part SSP and part company top up to get their 100% pay, or do you just pay company sick pay?
We pay part after day 4.
So say £23, if they earn £100, rough maths, £23 statutory sick pay and £73 of company sick pay, getting them £100 for the day. So you pay them the £23 for days 1 to 3, and then day 4 kick your company sick pay policy in, because that's a contractual provision that you provide to them. It's not a statutory provision, so you're still fine to keep it from day 4 only, but the first 3 days will be paid for SSP.
Perfect, that's what I thought, but thanks for clarifying.
And the reason I asked that about how you treat statutory sick pay from day 4 is that if you were paying 100%, and some people do, say for 12 weeks, then SSP would only start again after that period. So it'd be really complicated to treat the first 3 days, have a break, and then start SSP again. And of course, that will give 28 weeks on top of what you provided as contractual pay. I don't want to muddy the water with you there, but some people do pay just contractual pay. My advice is to have it as a top-up payment and always pay and identify the statutory sick pay.
Perfect, thank you. Appreciate your help.
Thank you. Alicia? Hi.
Hello. Sorry, just quickly. The stuff around the policy updates, would that all be updated from yourselves at THSP, or do we need to do that and then you review it? How does that work?
You're a customer. You will get an email on the 1st of March from our account executive team with the 3 policy updates on it. So if you don't get it, please let us know. But you will get an email with it on it. It'll come from your day-to-day contact with those policy changes on it.
Perfect. Thank you. Thanks.
And then we will update. And when it gets to your anniversary, your renewal anniversary, we will embed those in your staff handbooks.
Fantastic. Thank you.
You're welcome. Any other questions? This recording will be on YouTube in a few hours. So if you've got any colleagues or you'd like to reflect on it, then do so. If you type in THSP Employment Rights Act 2025, you'll find it dead easy. Resources are available, and you know where we're at. employmentlaw@thsp.co.uk. Connect to me on LinkedIn. Or call the office on 03456 122 144. I've done my admin bit now. If there are no other questions, then thanks again for everybody attending. This is a biggie for employers. It's the biggest I've known in HR and employment law. So please do take it seriously. I know you will, but if you need any help, then come and shout. Thanks, everyone.